Court rise. Yes, Mr. Knox.
My Lords, can I just mention one subsidiary point on the existing laws argument? And it's this, my Lords. The argument, as I understand it, would, or at least might have to turn on, showing that the regulations in question were inconsistent with the 1962 Constitution. In my submission, that's a rather unsatisfactory position, because normally one would want evidence as to what the position was when the regulations were passed, and certainly in 1976, when they were preserved. In the Saba Marta case, for instance, there was evidence, and the judge at first instance had gone into the whole history of the Order of the Trinity of the Cross, and therefore there was no objection taken to the board. I think the objection might have been taken, but the board saw no objection to dealing with the issue as to whether or not the award of the Trinity Cross back in the 1960s might be said to have been discriminatory even then. And likewise in Forester Bow, when the question was whether the mandatory death penalty might have been thought to have been inconsistent with the old Bahamian constitution back in the 1960s. Again, the board was in a position to form a judgment on that by reference to a whole raft of materials where one could say that even in the 1960s, that law would have been recognised to be cruel and unusual. It is slightly unsatisfactory that in this case, the premise of the appellant's argument would have to be that even in the 1960s, this law was not only discriminatory, that's one thing, but also unfairly discriminatory, such as could not be justified in the social context of the times, when we have no evidence whatsoever as to the background against which this law was then passed and understood.
It is, of course, directly discriminatory, compared with the Trinity Cross case, in which you had to say, no, that's indirectly discriminatory because of the...
Yeah, I agree
it bears differently on different groups, yes.
I agree there is that distinction, but it's not a satisfactory position for this board to be in, as we're sitting as a court of first instance without any material against which to judge the discriminatory effect, or whether it was seen to be unjustifiably discriminatory in the 1960s and the early 1970s. It's a subsidiary point. It's not my main point, but I submit it's not satisfactory that we're in that position. Can I turn to the second argument? Namely, that in my submission there is no inconsistency with the Constitution in any event. That's to say, these regulations are not unfairly discriminatory in any event. My Lords, my Lady, can I turn first to the police regulations, which are at tab 9. And before I go to the specific regulations in question, can I just show you the structure that these regulations have? In the initial stages of these regulations, they deal with appointments to office, probationary appointments, appointments of service, and how long you have to be on probation, and so on and so forth. Then come, in chapter 7, on page 534, sorry, chapter 6, page 534, to a chapter headed Resignations, Retirements and Termination of Appointments. And this is the chapter in which the relevant regulations are found. And you'll see section 44 deals with resignation. Regulation 45 deals with absence without leave. And then section 46. The services of a police officer may be terminated only for the reasons stated below. A, where the police officer holds a permanent appointment, then you have a series of alternatives, on dismissal or removal in consequence of disciplinary proceedings. I'll come back to that in a moment, if I may. Then 2, on compulsory retirement. Now, compulsory retirement is dealt with by regulations 47 and 48. You can see that later. On voluntary retirement, there's no regulation that deals with that. Then on retirement for medical reasons, that's dealt with by regulations 53 and 54. And then on being retired in the public interest, which is dealt with by regulations 49 and 50. and then you can see the other alternatives. And then there's a subsection B, which deals with the position of a police officer who holds only a temporary appointment. And then you see all the possible alternatives for removing him from service, including subsection 5, Roman numeral 5, two-thirds of the way down the page, on dismissal or removal in consequence of disciplinary proceedings. Now, one of the slight oddities of these regulations is they don't actually say quite what termination for inefficiency comes into. Because when you look at disciplinary proceedings, or rather when you look a little bit further on, if I can now just jump ahead, this chapter continues until chapter 54. And it's within this chapter you have the termination for inefficiency in 51 and 52. You then have chapter 7, which is conduct, which appears to have been revoked in 1990, but it dealt with, in the past, it used to deal with things like police, your general conduct in life and so on and so forth. Then chapter 8 is disciplinary procedure, and then basically regulations 75 all the way through to 101 set out a very detailed disciplinary procedure. And and then you get to regulation 101 on page 562, after all the various procedures set out for dealing with offences. Section 101, regulation 101, where on consideration of the report of the findings of fact by a disciplinary tribunal under regulation 96, the Commission is of the opinion that, then you have the alternatives, the police officer should be exonerated, A, or B, the police officer should be dismissed, the Commission shall dismiss the police officer, or C, a penalty shall be imposed. The Commission may impose any of the penalties specified in regulation 104, and then the penalty of dismissal from office as a consequence of disciplinary proceedings shall be imposed only by the Commission. And then you drop down over the page, I think, to regulation, a couple of pages, next page, regulation 104. Sorry, it's right at the foot of 564, you see 104, and then you go over to 565, is basically 104. The following are the penalties. So that's the slightly untidy structure of these regulations. Now, it's within that structure, you then go back to chapter 6, beginning at regulation 44, regulations, retirements and termination of appointments, that you have what appears to be a sort of special process set out in regulations 51 and 52. Query quite how regulations 51 and 52 come within any of the categories set out in 46. It may not matter very much.
Well, doesn't it come within one on dismissal?
Well, it may, yes. You read, I think, dismissal, then or removal from disciplinary proceedings, because clearly what's being set out in 51 and 52 is not the disciplinary procedure.
No, absolutely not.
So you have to, as it were, you use the or as very much a disjunctive or. Yes. Put it that way.
So I don't follow why are you finding 51 and 52 oddly placed?
Well, it might, it just shows that you have to read removal or, and that you might have read, one might have read in 46A1 on dismissal or removal in consequence of disciplinary proceedings. One might have read that as were dismissal in consequence of disciplinary proceedings or removal in consequence of disciplinary proceedings. But in fact, you have to read it as on dismissal, which could be as set out in this chapter, or removal in consequence of disciplinary proceedings as set out in chapter 8. And that's the only way you can, so to speak, make it work. If you're assuming tidy drafting. If you're just assuming that things may have got bolted on without much consequence, without much attention being paid to what was there earlier, that might be the other explanation.
How far does chapter 44 go? I've lost how far does chapter 44 extend?
Chapter
6.
Chapter 6, headed, starting at 44, finishes at 54 on page 542.
Yes.
And then you have the
Yes.
now repealed conduct, which dealt with things like turning up, dressing tidily in uniform, that type of thing. Then the disciplinary procedure in Chapter 8, which has got the provision for termination of employment for committing offences after the lengthy disciplinary proceedings that can be taken against you. And they're very detailed provisions for the disciplinary procedure. So, my lords, I just set that as the context, so one can see quite how these regulations fit in.
I was thinking I was a bit too quick to say that it comes within on dismissal and that or removal because of discipline is to be contrasted with dismissal. It does seem rather unfair to have your services terminated on the ground of inefficiency without a hearing.
Well, of course there is a hearing provided for by 51 and 52.
Yes.
And there is an investigation, but it's not the details.
Oh, I see, yes.
It's not when you look at the disciplinary proceedings, there are huge, I mean, there are endless regulations about what you can and can't do set out in the disciplinary section.
But there isn't actually a hearing provided for in 51 and 52. There's just the giving somebody notice and written representations.
No, there's an investigation.
Investigation. It doesn't say there has to be an oral hearing. It's
No. I mean, whether one should read that, so to speak, as somehow importing the particular procedure set out in the disciplinary procedure, that's not an argument that's before you today, but I can see the argument could be made. But it doesn't provide in terms for the nature, as well for the procedures to be followed within that investigation. I accept that.
Is there any difference between terminating the services of a police officer and terminating the appointment?
Well, I was wondering about that, my lord. That's the other possibility, but I was wondering quite where that would lead. Fine, your service is terminated, but your appointment's still there. It does seem difficult. I couldn't, my lords, I struggled to see quite how all these properly fit together. But that's what's there at the moment. Now, my lords, turning now to regulations 51 and 52, if I may, there's no doubt that, as Mr. Newman, QC, said, ex facie, regulation 52 appears to be providing for another ground, ex facie. In other words, on its face, one can see how, if you just look at the words themselves, you could say, well, this appears to be providing an extra ground of dismissal. If you just, for the moment, forget about what the common sense construction of this is. But my submission, and my lords, you could in theory construe regulation 52 to mean this, that the Commission could say to a normally super efficient woman police officer that, I'm sorry, you're no longer as efficient as you used to be, you're still quite efficient, but those family obligations are getting in the way of it. So I'm going to sack you under Regulation 52. You could, as it were, sort of posit that hypothetical example. And, my lords, just looking at the wording itself, you might say, oh yes, well, that you come within those words. But in my submission, that would be an absurd construction to place on those words and would have absurd consequences, and therefore that is not the construction which a court would in practice ever arrive at. And can I say why it would be an absurd construction? First of all, what possible point would there be in giving grounds to a commission to dismiss where there was no inefficiency proved? Just not quite as efficient as you used to be. It's absurd. No one. It's impossible to suppose that was the intention. That's the first absurdity.
Well, in the olden days, it was a disguised form of redundancy, basically. There were lots of professions from which married women were automatically excluded the moment they got married. This is a kind of halfway house. But part of that was undoubtedly motivated by the need to have sufficient jobs for the men to do. That's what
in this case,
meant
well,
that...
The trouble is, my lady, no doubt historically that might be the case, but it's very difficult. There's no suggestion that when this regulation was passed in Trinidad that was the thinking behind it. My lady, one might...
Well, was it carrying on from some earlier regulation to similar effect?
I haven't checked that, my lady. I don't know is the answer.
Well, it wouldn't surprise me.
even if it were the case, my lady, one has to give, one is always entitled to give a sensible construction. And the example I gave, and it's difficult to see what other sense could be given to it, I submit is of itself absurd, that you could dismiss someone even if they weren't inefficient. I submit that's not the intention behind the statute or the
They may be
regulation.
efficient, but they may be operating inefficiently because of their family commitments. It's affecting the way they can do their job. I mean, they're perfectly efficient. Before they took on these responsibilities, they were top
Yes.
class efficient people, but now they may be efficient in theory, but in practice, because of these responsibilities, they're not operating efficiently. It's got an effect on the way they operate.
Well, if they are no longer efficient, if they are no longer performing their obligations efficiency, and I submit that is what inefficiency means in 51(2), if they are no longer performing their obligations efficiently, well then they can be, the Commission's entitled to sack them under Regulation 51(2). But what I'm suggesting is that it's implausible to construe this regulation as really giving a power to terminate, even where there's no inefficiency. That is implausible on its face. That's, I submit, the first implausibility, or absurdities, I would say. The second point is this. What possible point would there be in excluding unmarried women, divorced women, and men from this regime? I mean, none. What purpose is served by that? How is the public interest and the police force going to be improved by that? Again, it's a nonsense to suppose that was intended somehow to make a special exemption for married women, when in fact, one could imagine an argument going the other way, namely that there should be a special exemption in their favour. And if that had been the attack on this regulation, we'd be in very different territory.
But Mr. Knox, again, you're looking at this in a completely unhistorical way. The reason for doing this is partly so that there should be full employment for men, because men were supposed to be looking after their breadwinning for their families, and also to encourage the women to be doing what they were supposed to be doing, which is looking after their husbands and having babies. Well, that's what these regulations used to be for in the olden days.
Well, my lady, I'm in difficulties, of course. I can't just give a blanket disagreeal. But the fact is that's never been the attack on them. But there's been no investigation into whether that was the purpose or the thinking behind them at all. And in any event, my lady, even if, let us say, even if in 1966, when this regulation was passed, even if that was, so to speak, the unconscious thinking behind it, I would respectfully say, so what if that was the thinking then? That doesn't affect the construction you place upon it now. And I submit that would be the answer to your ladyship's concern.
Efficiency, of course, is not an absolute concept.
No.
And therefore, why should this provision not be applied to the woman who is operating less efficiently than previously?
Because in my submission, it would be odd if she had not yet fallen to the level of inefficient. It would be
given that efficiency is not an absolute concept, there could be debate as to when that point was reached.
I agree, but in my submission, one shouldn't read the regulation as providing for that. Because again, that would be irrational.
So there's one unalterable standard to be applied to measure efficiency in every circumstance.
I wouldn't go as far as say one unalterable standard, but that the Commission can never terminate unless there is inefficiency. No matter what, but once there is inefficiency, it doesn't matter what the cause is. My lords, of course, one looks at the wording and one can see, as it were, a way of saying, no, there is something different here. But when you test it to see whether it makes much sense, I submit one gets the answer, not really.
Well, in the hands of malevolent administrators, I'm not sure that there would be quite the constraint that you suggest is inherent in the provision.
Well, in the hands of malevolent administrators, possibly. Of course. It gives a power. This is a separate point. It's a power, not a duty, of course.
If I was a married woman, I would perhaps not welcome the existence of that power, which could be used against me.
It sends a very aggressive message.
If I would accept, I would accept. Of course, it appears to be. It appears to be saying you in particular, as opposed to no one else. But my lord, my answer to that is, it is so odd to say. I mean, you've got my first two submissions. You know, what's the point, as it were, of excluding unmarried women, single men or divorced women? What's the point? And my lord, suppose, just try to work out the consequences of my learned friend's construction. Suppose a charge is levelled, not of inefficiency, but you're not as efficient as you used to be because of your family obligations. You're still perfectly efficient. If my learned friend is right, and there's a real, and that is the way of construing this, it would be a complete answer, presumably, for the woman police officer to say, you're wrong, I'm divorced. And so, end of charge. Now, I submit it's just implausible to suppose that that sort of scheme was ever thought of. Or she could say, no, you're wrong. The reason I'm inefficient, or the reason I'm not as efficient as I used to be, is actually because I'm having an extramarital affair. So, again, charge dismissed. This is a sort of absurd world which it leads to. And my lords, the other point is
That's why I said it is actually there to recognise and encourage married women to look after their husbands and families.
It may well reflect the social mores of the times, my lady, but that, I mean, you have my submission. I submit that that's not a reason for now saying it's unconstitutional, because you first of all have to work out what the proper construction to give it now is. But can I mention also one other point? What happens is under section regulation 52, you have a procedure for terminating the appointment in accordance with regulations 51, 2, 3 and 4. Now, so there has to be, first of all, a recommendation in writing that the appointment of the police officer should be terminated on grounds of inefficiency. Now, I suppose one might say inefficiency caused by family obligations, or anyway, you have some sort of charge. She's given an opportunity of making representations. Representations in subsection 3 are forwarded to the Commissioner, and then the Commissioner may, upon application of the police officer, cause an investigation to be made. Now, theoretically, you could say the investigation would focus on the cause of the inefficiency. And it would be rather an intrusive investigation, namely, we're not interested at the moment in the question of inefficiency, we're interested in the cause of all this. Now, again, I submit that to construe the regulations as providing for that type of investigation, as opposed to an investigation into efficiency or otherwise, again, would be absurd. So, in a sense, part of my argument, it might be said to be turning my learned friend's argument on his head, is, well, if these regulations are as aggressive as put by Lord Collins, or if they have the effect which is contended for, they do have some very surprising and absurd consequences. And in my submission, the proper way of reading these regulations, even if this wasn't necessarily exactly how they were intended at the time, is simply to read them in the way I suggest, namely as providing that it is not a complete answer to a charge of inefficiency, that the cause of the inefficiency is your family obligations.
So does that mean that if the Commission purported to terminate somebody's appointment under Regulation 52, that would be bad?
My lords, it would be unless there was a finding of inefficiency. If there was a finding of inefficiency, then it would be a perfectly lawful termination. If, however, the finding was only, if there was no finding of inefficiency.
How do you construe 52 then?
52
does give a power of dismissal?
It gives a power of dismissal, but you have to read on the grounds that her family obligations are affecting the efficient performance of her duties, as meaning so as to make her inefficient.
But not as a result of a number of adverse reports.
If I may come on to the adverse reports in a moment, but that's I take the Lordship's point. It may be that the only distinction would be, oh well, there don't have to be a number of adverse reports. But my lord, that of itself wouldn't, in my submission, make this an unfairly discriminatory provision. And even then, you could still read this. There are going to have to be some adverse reports on the inefficiency in any event. You could still read it as providing by necessary implication that there have to be a result of a number of adverse reports on the inefficiency.
Well, I wonder whether that's right. Let's take the case of a superior officer who feels that one of his married female police officers is not performing as efficiently as previously.
Yes.
Can he not commission an investigation into efficiency, even accepting your argument, without there being a number of adverse reports?
My Lord, in my submission, no. Because Regulation 52, well, you have to read back, it reincorporates the procedure set out in 51, and then you go to 51.4. Now, the Commission may, upon application of the police officer or on its own motion, cause an investigation to be made. My Lord, that would only apply, in my submission, once there's been an initial recommendation. In other words, you can't just have a sort of free-floating investigation at any stage. There has to be an initial recommendation made by the Commissioner that the appointment of a police officer should be terminated on the grounds of inefficiency. And it's only at that point that you get the investigation going. I agree, my Lord, it might be said to be rather intrusive to have some sort of free-floating investigation which can be called on at any time. But in my submission, that's not the proper construction to give to the regulation. And also, I fully accept, of course, that in one sense I'm reading down these provisions, but I submit one's entitled to do that, and one reads them sensibly to get to a sensible result. And
Compatible with the Constitution.
But also, when one thinks of the absurdity of some of the consequences from which my learned friend is concerned, is arguing, it's not that unlikely that that certainly is the construction that now would and should be placed upon them. And maybe even what was always intended in the very beginning. And my lords, of course, what I say is the reason why it is married women who are singled out is precisely because it was always assumed that they would be the only people who would ever seek to invoke this argument. Can I just turn briefly now to the other regulations, which are similar but not identical. In tab 8, well, they're also in tab 7. You have a very similar structure in these regulations to the police service regulations. And you can pick the point up on page 465, part 6, resignations, retirements, termination of appointments. Part 6, section 48, 465. And you have regulation 50, which is the equivalent of the other regulation 46, which sets out the basic powers of dismissal. And you see the same language used, and there are parallel provisions. They also appear to have thought, this is passed in 1968, they've also added a subparagraph 8 over the page, on page 466, near the top. On such other grounds as the Commission may determine. You then have, still within the same chapter, regulations 57 and 58. And then in page 470, you have part 7, conduct, which has been repealed from the police service regulations, but is still, it seems, in force in relation to statutory authorities regulations, which deals with how you're supposed to behave and so on. And one point I should draw attention to is in regulation 83, is misconduct defined. You'll see the subparagraphs 83(1)A down to D, guilty of misconduct, and that makes you liable to punishments prescribed in Regulation 110. And then you'll see over the page, subsection 2, without prejudice to the generality of sub-regulation 1, an officer who, and then you'll note in particular 2D, inefficient or competent through causes which appear to be within his own control. So that appears to be misconduct. It's guilty of misconduct and liable to such punishment as is prescribed by Regulation 110. And then you have part 8, you have the disciplinary code and procedures. I think in, again, very similar terms to the police regulation procedures, and then regulation 110 on page 490, the various penalties. Turning back to regulation 57, page 469, I think I'm right in saying, save for 2 points, these regulations are on identical terms. The first point is 57, 1, 2 and 3, doesn't have a 4, corresponding to the police service regulation. That's to say, it doesn't have
investigation.
it doesn't have an investigation, yes. And then 58, Commission may terminate the appointment of a female officer who is married on the grounds that her family obligations affecting the efficient performance of her duties, and the procedure for the termination of such appointment shall be in accordance with Regulation 56, 2, 3 and 4. My Lords, I must admit I wondered whether in fact that was just not a mistake, because what they were doing was they were copying the police service regulations, which do indeed have a subparagraphs 2, 3 and 4. They then noticed there isn't a 2, 3 and 4, and then they then put in Regulation 56 instead of 57. One cannot help thinking it's all very peculiar, because when you go back to 56, 2, 3 and 4, there is a sort of form of procedure, but it's not quite so easy to marry up with what's going on in 58.
Well, it's a different context as well, isn't it?
Yes.
If you're being considered for removal under 56.2, it's, I should think, a rather less pleasant prospect than under 57, because that's where it's necessary to retire or remove an officer for the service of the statutory authority for the purpose of facilitating improvement in the organisation generally.
But and it's not really a procedural provision. I mean, it's a bit odd to say 56.2 is a procedure. And likewise, 3 and 4. I mean,
it is a procedure, because the head of the particular statutory authority has to make a report to the Commission.
Yes.
So that's a procedure, because obviously we're talking about something which regulates not just a single police service, but a number of different statutory authorities. And so clearly the thing starts with the statutory authority and shunts off to the Commission.
Yes. But I agree, there is, you can sort of get procedures, and then in subsection 3 there is a sort of, well, there is that is a pure procedural provision, but you've only got 7 days' notice rather than rather tighter time limit. Then 4 is in fact the same, I think. The representations are forwarded to the Commission. The only other difference is that, of course, you don't have to have numerous adverse reports. Well, my Lords, my Lady, I just make the same submission on these regulations as I do on the former ones. My Lord, I think that brings me on to my third point, namely that these proceedings are, with respect, somewhat academic. The Constitution, it's in tab 4, the first bundle, section 14,
Sorry, which page?
24 at the top,
Okay.
section 14, general. This is part of the fundamental rights provisions. 14, for the removal of doubts, it is hereby declared that if any person alleges that any of the provisions of this chapter is being or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the High Court for redress by way of originating motion. What I emphasise there is has been, is being always likely to be contravened. Then the High Court shall have original jurisdiction to hear and determine any application and so on, and may, subject to subsection 3, make such orders, issue such writs, give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of the provisions of this chapter, to the protection of which the person concerned is entitled. Now, in my submission, there is no evidence that the commissions have ever applied the regulations in question in an unfairly discriminatory way, or that they intend to do so. That's not been the basis of this application at all. And in my submission, that is important, because I would accept that the regulations give only a power. They don't impose a duty, they give a power. And that power has to be exercised rationally in accordance with usual principles of public law, and also in a way which is consistent with constitutional rights. If, therefore, the power were at any point exercised in a way which was inconsistent or in a discriminatory way or irrational way, then at that moment one could say that the provisions are likely to be contravened, or they are being contravened, or they have been contravened. The rights have been contravened. But at the moment, my lords, the position is simply this. You have what can be said is a couple of regulations amongst a plethora of regulations where there is no suggestion that they are going to be enforced in an irrational way or in a way which is unfairly discriminatory. In my submission, therefore, this application is premature and doesn't satisfy the requirements in section 14 of the Constitution. And it's an important point, because otherwise you can probably pick on all sorts of regulations all over the place and say, well, you know, one day I might just be affected by that regulation, and therefore please give me a declaration now that the regulation is unlawful or unconstitutional. Where you have the difficulty, I submit this board faces, of really deciding the case almost in a vacuum, without reference to any particular facts at all. And the only fact you have is the obviously unsatisfactory fact and difficult to believe fact, namely, I'm deterred from getting married because of Regulation 52 or Regulation 58. And it's got an air of unreality about it. And there's not a satisfactory way to deal with these types of application.
Why do you say it's an air of unreality?
Well, my lady, I submit that the mere prospect, if I knew that, if there was evidence in this case that the Commission routinely or very often applied these regulations in a discriminatory or unfair way, as one would see it, then I would accept. One might say, well, there is a burden in getting married here. I'm a female officer. I want to get married. I don't want to prejudice my job because I know that if I do, I'll be taking on family obligations, and there is a real risk that by doing so, I'm going to face a sort of a procedure or possible sanctions which don't apply to me at the moment. One can see that argument. If, in fact, the position is that there's no real, it just doesn't happen, then I submit there is an air of unreality in those circumstances, especially if there's no evidence that it's not clear that this is how the regulation has to be applied, and it certainly never has been applied that way. That's what I say.
Supposing that the regulation were introduced today,
Yes.
so you would have no question of existing laws, would it then be open to the Commission to say, oh, well, you know, we're never going to apply that? Or is it only because it's been lying around that somebody is entitled to say it's not likely ever to be applied? Well,
I think partly, if it were introduced today, it wouldn't be easy to say it's not likely to be applied. I think that might be one answer to your Lordship's point. I mean, the very fact of its introduction would give rise to the inference it is going to be applied and it would also give rise to the inference that perhaps it was a very odd sort of regulation to bring in today.
You are struggling to maintain it.
Well, my Lord, in one sense I'm struggling to maintain it, but I'm only doing so, if I may say, by reference to an argument which takes the sting out of it.
Well, yes, you're doing that, but I mean, it's just come to... This is the first time this argument has been advanced, as far as I know.
No, my Lord's in the Court of Appeal, my Lord. You'll recall too there. So it's not as if... And I think at first instance this argument wasn't specifically advanced, but at that point the case was being advanced on a rather different basis, namely the whole regulation was completely unfair and had to be completely got rid of, was void in its entirety. So, my lords, I take your lordship's point, but it is important to see how this case has progressed. And the position I'm adopting now is not a totally new one. It is the position that the Attorney General. My lord, it's terribly important to remember, I'm acting for the Attorney General. I can't tell the police, I can't tell the commissions what to do. No doubt we might make recommendations, but even then there are difficulties, because one has to be quite sensitive. People in different spheres telling other people what to do, they don't like it on the whole.
But you don't feel inhibited from telling us what the Commission is not going to do.
Well, the reason I say that is because it's not, in one sense, for the Attorney General to say what the Commission should or shouldn't do, but what I can say on his behalf is how the law should be interpreted. I mean, this is a constitutional challenge, and the question arises, is this law contrary to the Constitution? Now, that is a matter within the remit of the Attorney General. And so he can,
But going back to my Lord's question to you, if it were introduced today, I think that the substance of your answer was that it would be rather more difficult to defend, and that,
yes.
that doesn't come as a surprise. If one is a married woman contemplating the prospect of the invocation of this regulation, obviously, if you're confronted with its sudden enactment today, then you can realise that it's entirely feasible that it will be invoked against you. If, on the contrary, you see the government defending the retention over many years, despite a challenge, surely a married woman is going to say to herself, well, despite all these declamations, it's entirely feasible that this will be invoked against me.
Well, I think if they were to know the story, namely that in the Court of Appeal and on the appeal to Privy Council, the Attorney General disavowed any case that they were to be applied, save in the way that I say, then that concern would be taken away.
Well, I'm not so sure about that.
Supposing we held that your interpretation wasn't correct, wasn't maintainable, then what?
Well, then the position is the law is still saved as an existing law.
Yes.
But of course, there's still the argument, of course, that it can.
Yes, but as far as the standing, that's the answer. But I mean, as far as the standing of the women to bring the thing, what then?
Well,
you were in a position to say it would never be applied. You were in a position to say they.
No. But my respectful submission, the test is not whether it will never be applied. But I take your lordship's point. Of course, I can't give that on. I'm not the Commission. But what I can say, my lord, is the test is being always likely. That's the point. And if you were to read the Constitution as being, if I have to get to the will never be applied test, I'm never going to satisfy that. It's the is likely, and that's the point. It's a short point.
The point is, this provision does apply to any woman police officer.
I can see
it applies.
Yes, my lady, I can see. It might be said, well, it applies in the sense that it forms part of their terms and conditions of employment. To that extent, it already applies to them, and therefore, to that extent, there is a contravention. I accept that's how the argument against me goes. To which I say that in constitutional matters, one takes a broader view and asks, well, is it likely to be, especially bearing in mind the obligations imposed to use that power reasonably and in a non-discriminatory way? I don't resile from that at all.
It's a bit like the Dudgeon case, isn't it?
Sorry?
It's a bit like the Dudgeon case.
Yeah.
It's the same kind of thing.
The maintaining of discriminatory provisions on the statute book is itself a detriment to the person concerned.
There's a chilling effect here. Both these ladies say that they're deterred from getting married because I suppose what they're saying really is if I get married, they'll be watching me much more carefully than men.
Yes.
They'll be looking for a reason.
Yeah, so yes, they didn't quite put it that way, if I may say. But
there's no evidence in reply, is there?
Sorry?
There was no evidence in reply.
No. Well, it was a very sort of short, neat little point that was taken. I can see that. But that, of course, is a slightly different objection. I mean, in one sense, the objection there is marriage, as opposed to I'm a woman. It's a rather, in that case, one gets to the question, as were mooted by Lady Hale, namely, is this discriminatory or contrary to the Constitution, both on the grounds of sex discrimination and also on the grounds of marriage discrimination?
Well, it is both. I was making that point in relation to the comparison with married and unmarried women. But in fact, no man has to ask himself, shall I get married or not? Because it will add to the grounds on which my employment as a police officer may be terminated.
Yes.
He doesn't have to ask himself that question. Every woman does.
Yes, I mean, in theory, my lady, yes. I would accept there is, I mean, if that provision was drawn to their attention, I do accept, but there, in one sense, yes.
Come on, Mr. Knox.
But anyway, I take your ladyship's point, but this is, you have my submissions. These regulations have to be applied in any event consistent with the Constitution. That's the basic point. Now, I accept that might not be a complete answer, but that's what I say on the academic, the third ground. My lady, just as far as whether, just if I make a point against myself, on the question of whether there is a right, so to speak, not to be discriminated against on the basis of marriage, you might, I think, refer to section 4C, and that might, I would have thought, might encompass, or indeed 4D, 4C and 4D, I would have thought, the right to the individual respect for his private and family life, well, that might be said to be inconsistent with that, if you're deterring people from getting married and having children. And again, 4D, equality of treatment. Might be said you're not given equality of treatment if you're a woman who's subjected to this if she gets married, whereas if you're a man, you're not subjected to this if you get married. I think that's how the argument would go. But there it is. I don't think, unless there's anything else, my lord, my lady, those are my submissions.
Thank you very much indeed. Sir Fenton.
Lady, you'd be kind enough to allow other people to reply.
Yes, absolutely.
My lords, my learned friend provided a number of submissions about the effect of section 18 of the 1976 Act. May I invite you to look at section 18, which is at page 109. Making the assumption that the regulations are enactments made by a person or authority, making that assumption, can I focus on the next few words, under or by virtue of the former constitution? Now, so far as the statutory authorities, service, commission regulations are concerned, and that only applies to those regulations, not to the police regulations, it's my submission that they were not made under or by virtue of the former constitution. What was made, my learned friend took your lordships and my lady to section 36 of the 1962 constitution. If we can look at that at page 41, please.
Sorry, which page?
Page 41, my lord.
Line bound. Yes, thank you. Yes.
My learned friend took the board to section 36. Subject to the provision of this constitution, Parliament may make laws for the peace, order and good government of Trinidad and Tobago. That's section 36 of the 1962 constitution. Now, it was under that provision that my learned friend seeks to argue that the Statutory Authorities Act was passed, and I don't dispute that. There's nothing in the Act which says that it was passed pursuant to section 36, but I accept that that power is wide enough to permit the passing of statutes in accordance with the Constitution. But the actual regulations that are in question were not made as an Act of Parliament. They were regulations made under the Statutory Authorities Act, section 6. If my lords would be good enough to look at page 447 in volume 2. I'm sorry, I have the wrong. Yes, 447. One sees at the top Statutory Authorities Service Commission regulations made under Section 6. That's Section 6 of the Statutory Authorities Act. It cannot, in my respectful submission, it cannot be said that regulations made pursuant to an ordinary Act of Parliament were made under or by virtue of the Constitution. Otherwise, absolutely everything that's ever passed, whether it be regulations or orders in council or whatever it might be, were all made under or by virtue, would all have been made under or by virtue of the Constitution.
How can you make laws which are not made under the Constitution or by virtue of the Constitution? You've got other, I mean, it's a country which has got a Constitution.
Yes.
Can you make laws outside the Constitution?
It's not a question of outside. You can't make laws in my submission which are contrary to the Constitution, but that doesn't mean to say that you're making it under the Constitution. I mean, if I can contrast these regulations with the police service regulations, there was a provision in the Constitution, which I'll turn to in a few minutes, but there was a provision in the Constitution saying you may, giving the authority to make police service regulations. Regulations which are made pursuant to an ordinary Act of Parliament, the Statutory Authorities Act, are not, in my respectful submission, made under or by virtue of the Constitution. They're certainly not made contrary to the Constitution, and they can't be made contrary to the Constitution, but that doesn't mean to say they're made under or by virtue of it.
Well, the source of authority for the regulations is an act passed by Parliament.
Yes.
And the Parliament passes the Act by dint of Section 36.
Yes.
So the ultimate source of the regulations has to be Section 36, does it not?
The ultimate authority for the passing of the Act is Section 36. The authority for the passing of the regulations is, as is stated at the top of the thing, Section 6 of the Act. So that in my respectful submission, the statutory or authority service commissions regulations were never made under or by virtue of the former constitution and are therefore not, so to speak, saved as an enactment by virtue of Section 18 of the 1976 Act.
So take what is now called the Senior Courts Act, formerly the Supreme Court Act. That allows rules to be made under it, and the rules themselves, I think, allow some other body to make practice directions. You say that the practice directions are not made under or by virtue of the Senior Court
Yes,
Act.
I do. They're not contrary to it, but yes, I do, my lord. I don't
Seems to be
resolve
an
them.
impossible submission.
Well, Lord, obviously, I'm not going to develop it. May I see whether the next submission, also on these regulations, the Statutory Authority Services Commission regulations, finds more favour with the board?
It's very refreshing to have impossible submissions
Yes, very
directed
good.
at us from both sides of the case.
Now, this was discussed in the course of Malone and Friends submissions. The SASCR, if I may call them that, because it's a bit of a mouthful otherwise, Statutory Authority Service Commission regulations, the SASCR were made pursuant, as is stated, to Section 6 of the Act. Can we contrast Section 6 of the Act with Section 28 of the Act? At flag 8 in Volume 2.
Seven, I think.
No, not flag 8, I'm so sorry.
Flag 7, I think.
Flag 7. Yes, no, it's not the regulations, it's the Act.
Yes.
I'm very grateful. Page 337 is Section 6, and page 347 is Section 28. Now, it's my submission that on a proper reading of Section 6, that permits the Commission to make regulations relating to the procedure for the various matters which are spelled out there. It can make regulations to regulate its own procedure, which includes the procedure for the appointment, promotion, transfer and removal for office of statutory authorities. And again, although the word procedure is not repeated, it must mean that, and for procedure relating to the exercise of
No, it doesn't say
discipline.
that. No, you're adding words.
Yes, my lord. But my lord, well, my lord, in my respectful submission, that's the obvious construction of Section 6. Well, I don't have to add the words procedure again. It's there in any event. Regulate its own procedure, including the procedure for and the exercise of disciplinary control, all of which are the procedure. Because, as my lords and my lady pointed out, the wider powers are really given to the President under Section 28 of the Act, at page 347. For example, in 28A, the President may make regulations for prescribing the terms and conditions of employment in the service of the statutory authority. And that, in a sense, in my respectful submission, dismissal because you're not quite as efficient as you might have been before you had a baby, it comes within 28A. Now,
so is this a new ultra vires argument?
Well, it stems from Malone and Friend's submissions that he was making concerning the... This was a matter of debate between my lords and Malone and Friend a few minutes ago, or before the lunch with short adjournment. I'm hoping to spell out the consequences of Malone and Friend's submissions. I mean, well, my lord, so if this was a matter ventilated, I think by my lord, my lady Hale certainly, and others on the board with Malone and Friend, and if that's right. If it be right that Section 28 is the proper section under which the regulations should have been made, then it would have the effect that those regulations were, in a sense, null and void. They were ultra vires, the power of the Commission. And they were never existing. Existing law, in my submission, means that in some way it must have been passed as proper law. What is preserved is something which is properly passed as law. And if it's right that there was no authority in the Commission to make the regulation 58, which they did, and I'm not concerned with all the other regulations, I'm concerned with regulation 58 alone. If it's right that there's no authority in the Commission to do that, then in my respectful submission, they are not saved later on by Section 18 of the 1976 Act. Even if it's an enactment, it's not a valid enactment. So those are my submissions concerning the Statutory Authorities Service Commission regulations. So far as
it is, I think, relevant in looking at the very terse drafting in Section 6 and also in Section 5 to note that there is a definition of officers which very plainly refers to statutory authorities. You see that at the top of page 336.
Oh, yeah, so sorry, yes. Yes. Lord, but officers are also used in Section 28 as well.
Indeed.
Yes. Well, my Lord, on my submitted construction of Section 6, Section 6 is dealing with regulations concerning procedure for the various matters which are there spelled out. I hope the board doesn't consider it to be such a bad argument as the first one, but that would be my respectful submission at any rate concerning the construction. And therefore,
it'd have to be quite bad to be as bad as the first one.
Nothing could be as bad as that. At least I'm improving as time goes on. By the end, I may find there may be a point which finds favour with the board. Lord, that's all that I wish to say about the Statutory Authority Service Commission regulations. So far as the police service regulations are concerned, the same argument, good or bad, is not available to me and I don't make it. But what I do say is this. It is self-evident from the regulations themselves that they were made under Section 102 of the former Constitution, which gave them empowered them to make such regulations. If your lordships, my lady, would be good enough, please, to turn to page 104, no, page 82, sorry, page 82 on the bottom left-hand corner. My learned friend Mr. Knox took the board to section 102, subsection 1 and subsection 5. So that was the power under which the Police Service Commission regulations were made. When those regulations, when the 1962 Constitution lapsed and was replaced by the 1976 Constitution, the Police Service Commission regulations remained in being, and they remained in being. We can see how they remained in being on the face of the regulations themselves. Can I please ask my lords and my lady to turn to page 504. Page 505, actually, probably more useful. Page 505. In small print, about a third of the way up from the bottom of page 505, the regulations state as follows, or the margin note of it states as follows. These regulations were made under section 102 of the former Constitution and continuing in force by virtue of section 29(3) of the Interpretation Act. So the validity of those regulations is accorded by the provisions of section 29(3) of the Interpretation Act. Can I invite my lords and my ladies to look at section 29(3) of the Interpretation Act?
It's a fresh argument.
No, it's a reply to my learned friend. It's at flag 6, and it's certainly in our case.
Oh, it's certainly in your case.
If your lordships and my lady would look at flag 6 and go to section 29(3, and it's 29(3)A, which is the provision that I would wish to focus on. Without prejudice to subsection 2, where a written law repeals or revokes a written law and substitutes another written law, therefore, by way of amendment, revision, or consolidation. And the two written laws I'm talking about are the 1962 Constitution and the 1976 Constitution. Where that happens, all statutory instruments or statutory documents made, issued, confirmed, or granted under the old law, all decisions, etc., issued, given, or done thereunder, shall, insofar as they are in force at the commencement of the written law so substituted, and then there are these words, and are not inconsistent therewith, have the like effect, etc. So, what section 29(3) is saying, you continue with the regulations that were made under the old law, and they've got like effect under the new law, but only to the extent that they are not inconsistent therewith. And it would be my submission, for the reasons already advanced, that section 52, or regulation 52 of the police service regulations, is inconsistent with the provisions of the 1976 Constitution, and for that reason are not continued in force by virtue of the application of section 29(3) of the Interpretation Act.
So you said they're inconsistent with?
Inconsistent with sections 4 and 5 of the 1976 Act, of the 1976 Constitution.
Even though they're existing laws?
Their existing law, which brings into effect, if I can put it that way, section 18. But I'm not relying on section 18 at all. I'm relying on a completely different...
You're not relying on it, but the other side is relying on it.
Lord,
I mean, the question is were they existing laws? This may be a way of saying that they continue in force. The question is, are they caught then, if they continue in force as existing laws, are they caught by sections 18? If they're caught by section 18, then we don't get into the argument.
well, in my submission, that is giving no effect to... You've got two statutory provisions. One is section 18, but the other is section 29(3) of the Interpretation Act. And your Lordship's
But aren't we
indication-
back at the Matthews point? Is this precisely the Matthews point? This can't be inconsistent with the 76 Constitution if it's saved by the saving for existing laws, and it falls within the existing laws if it's caught by Section 18.
My lady,
Isn't it exactly the same point?
I don't want to weary the board by repeating...
Which I have at long last got my head round.
Well, I've made the point, my lady and my lords. I'm not going to insist on the point. Lord, my learned friend then says that whether it's Section 52 of the Police Service Regulations or Section 58 of the other regulations, he says that really, as a matter of practicality, Section 52 would only ever be applied if, in fact, there was inefficiency rather than just some minor matter. There are a number of answers to that. The first one is that if that argument is right, there would be absolutely no need whatsoever for Section 51. It adds nothing at all to Section 51, subsection 2 of the Act, which allows for termination on grounds of inefficiency. That's the first point. The second point is that Malone and Friend's submissions completely ignore the difference between termination on grounds of efficiency and matters affecting the efficiency of a particular performance, as has been identified in the course of the questions asked of Malone and Friend. A person can be marginally less efficient, but nevertheless still efficient, and be liable to dismissal under Section 52. The evidence in this case, such as it is the evidence of the two applicants. The government have not chosen to put in, or the Attorney General have not chosen to put in any evidence by way of reply. So that is the evidence in the case. And the evidence in the case is that they are affected in their approach to marriage as a result of that provision. And it's not a question of being likely in the future sometime to be affected. As my Lady Hale pointed out, they are presently affected. They are presently affected in the sense that it has a chilling effect on their decision whether or not they might want to marry. And it would be an odd provision. Section 14 would be an odd provision relating to the safeguarding of a person's constitutional rights if they had to have those rights infringed and only then could take proceedings. That would be a construction which I would urge your lordships and my lady not to adopt. The other point is this: if in fact they're so OTOs, Section 52 and Section 58, depending on which regulation one's looking at, there have been quite a number of occasions when the regulations have been amended, and that's apparent from the face of the, let's take the police regulations. If I invite you to look at page 500, we can see on the face of it, at page 100, about a third of the 500, about a third of the way up. One of the provisions was revoked by a particular instrument. That's on one occasion. Then at page 501, another provision, section 76 this time, was revoked by another instrument. And there would have been plenty of opportunity, therefore, to have revoked section 52 in this case, 58 in the other case, if in fact they were so meaningless and so OTOs. And yet they haven't been revoked. And with due respect to the learned friend, I would invite this board to say that it's hardly a guarantee of anyone's constitutional rights to have to rely on executive goodwill as to whether or not they in fact take proceedings under a provision which clearly gives them a power of dismissal. Lastly, just if I may just mention this, on the question of costs, Can I invite your lordships and my lady to adopt the normal procedure, which is to say that to allow 21 days after judgment for submissions to be put in, because obviously at the moment it's impossible to.
Do you agree with that, Mr. Knight?
Well, unless I can assist the board further, that's all that I have to say.
Thank you, Mr. Newman. The board is grateful to counsel and instructing solicitors on both sides for their submissions, both in writing and orally. The board will take time to consider their judgment.
So there we are.